Hey, Legal Eagles, it's time to adjudicate the matter of Judge Kavanaugh versus Dr. Christine Blasey Ford. All right, let's think like a lawyer. Like most of the country, I've been glued to the Kavanaugh-Ford hearings. Regardless of what side of the aisle you stand, I think it raises important questions for our country. It also raises particular legal issues that I think deserve a thorough debate. So today, I'd like to give you the first real law review of the Kavanaugh-Ford hearing from the perspective of a lawyer. This will be the first in a new series on this channel where I try to tackle the most important legal issues of the day. If you have a suggestion for the next legal topic I should cover, please leave that down below. And if you disagree with me, be sure to leave your comment in the form of an objection. And by the way, if you'd like to see me critique your favorite legal TV show like Suits or Better Call Saul, check out my Real Lawyer React series. The link for that will be down below. Now, there are 5 questions that I want to cover today. Number 1, did Judge Kavanaugh commit legal perjury? Number 2, did he display a judge-like temperament? Number 3, would Judge Kavanaugh prevent investigations into President Trump or the White House? Number 4, would the current allegations of sexual assault hold up in court? And number 5, should Judge Kavanaugh have requested an investigation by the FBI? Now, before we begin, on a personal note, this is not meant to be a partisan analysis. I'm not going to give you my opinion on whether I think Judge Kavanaugh should be elevated to the Supreme Court based on his judicial philosophy or his political views. I'm a lawyer first, and that's the perspective I'm going to try to give you. Oh, and one last thing. This is Stella the Legal Beagle. She reads all of your comments. Now, I want this to be a hearty debate, but I want it to be a civil debate. If you wouldn't say it in front of Stella, please reword it so that it's Stella appropriate. All right, so with that out of the way, let's begin. So question number 1, did Judge Kavanaugh commit perjury? Now, perjury is a very specific crime. Taken from Title 18 of the U.S. Code, perjury is defined as having taken an oath before a competent tribunal that he will testify truly and contrary to such oath, states or subscribes any material matter which he does not believe to be true. Now, looking at a lot of the footage from the hearing, it seems to me that a lot of Judge Kavanaugh's answers appeared to be evasive and non-responsive. For example, Judge Kavanaugh was asked what Ralphing referred to in the context of Beach Week, and he defined it as referring to his chronically weak stomach from eating spicy food and that he can't really keep his food down.
Let's look at Beach Week Ralph Club biggest contributor. What does the word Ralph mean in that?
That probably refers to throwing up. I'm known to have a weak stomach, and I always have. In fact, the last time I was here, you asked me about having ketchup on spaghetti. I always have had a weak stomach.
Judge Kavanaugh was asked to define Devil's Triangle as it appeared in his yearbook. He defined Devil's Triangle as a drinking game and not any kind of sexual act.
Devil's Triangle?
Drinking game.
How's it played?
3 glasses in a triangle.
And?
You ever played quarters?
No.
Okay, it's a quarters game.
Judge Kavanaugh was also asked to define Renata alumnus as it appears in his yearbook. He explains that that refers to being friends with a woman who went to a neighboring high school.
You mentioned, I think, the Renata, I don't know how you pronounce that. That's the proper name of an individual, you know?
Renata?
Renata? It's spelled with an E at the end, R-E-N-A-T-E. Is that
correct?
Okay. And then after that is the word alumnius. What does the word alumnius mean in that context?
I explained that in my opening statement. She was a great friend of ours. A bunch of us went to dances with her. She hung out with us as a group. The media circus that has been generated by this thought and reported that it referred to sex. It did not.
Now, given that I was once a 17-year-old boy, it seems to me that a lot of these answers are evasive at best and flat out wrong in the worst case, and that a lot of these terms simply don't jive with the common understanding of a lot of the way that these words would be used. Some seem unrealistic. But perjury requires a very specific mens rea, that you knowingly state something that is false under oath. It's possible that he and his friends had very idiosyncratic definitions of some of these words. Perhaps they were taken out of context. And on top of that, it would be very difficult to find a definitive guide on what these words actually mean. Language is always changing. But I think a lot of the problems stem from the Democratic senators failing to pin Judge Kavanaugh down to an actual definition. If you were to think of this hearing like a deposition, the point is not necessarily to argue or get a Perry Mason-like admission, but to lock down the witness into a specific story and a specific definition. You lock them down so they can't back out. And you can go down the rabbit hole to show how ridiculous it is. Now, normally you don't ask the witness questions you don't know the answer to. But if you know that the answers are going to be fairly ridiculous, then you want the witness to explain all of the repercussions that come from the idiosyncratic or ridiculous view that they're taking. And so you want to take them down that road and take it to an extreme to show how ridiculous it seems. Here, a lot of the Democratic senators failed to ask follow-up questions that would have pinned down Judge Kavanaugh. For example, when he refers to the Devil's Triangle as a drinking game, you could really pin him down to show how ridiculous that is. You could say that it's your testimony that the Devil's Triangle is a drinking game, correct? You get a yes answer. It's your testimony that the Devil's Triangle does not refer to a sexual act of some kind. He'll probably answer no. It's your testimony that the Devil's Triangle does not refer to a sexual act with one woman and two men. He'll probably answer no again. The senators could have followed up about his weak stomach. They could have asked if he throws up every time he has spicy food. They could have asked when was the last time he had Indian food? When was the last time he had Mexican food, Cajun food? And just go down the line. And granted, they might not be able to get him to admit that maybe he has spicy food more often than he lets on, and maybe he doesn't vomit every time he has it, and that the vomiting probably relates to drinking more than it does to having a quote-unquote weak stomach. But what they can do is lay the foundation to catch him in falsehoods later on. That's one of the big issues with this particular hearing, is that a lot of the senators were trying to argue at the same time they were trying to ask questions. And as any trial lawyer will tell you, you cannot argue at the same time you're asking questions. Those are two separate functions that need to be separated. So the Democratic senators should have done a better job of separating the cross-examinations from the arguments to do a better job of laying the foundation for catching Judge Kavanaugh in outright falsehoods. As in court, one's character for telling the truth on the stand is almost always relevant. And if you lay the foundation just getting out facts that don't seem reasonable, then perhaps after the hearing is finished, you can go do some investigations and find evidence that contradicts what Judge Kavanaugh stated on the stand. And I suspect if they had asked better follow-up questions, they would have been able to do that. And if we're thinking about these particular questions as a cross-examination, like what would happen in trial, a lot of the questioners allowed the witness to evade the question. They fell for the witness's obfuscation and abandoned their original question. And as any litigator will tell you, if you don't get an answer to the question that you ask that exact question again, and you ask that exact question until you get the answer that you're looking for. So for example, when Judge Kavanaugh was asked, would you want Mark Judge to testify on your behalf? The senator asked the same question once, but then he abandons that question to then argue with the witness, falling for the trap of wasting his time on argument instead of following up with the exact question.
If she's saying Mark Judge was in the room then he should be in the room here today. Would you want him called as a witness?
Senator, this allegation came into the committee.
Oh, no, but I'm just asking the question. Would you want him to be here as a witness?
He's already provided sworn testimony to the committee. This allegation's been hidden by the committee, by members of the committee.
It has not been investigated by the FBI. The committee has refused to allow it to be.
It was dropped on me. It was sprung.
It was not investigated by the FBI, and he has not been called where he might be on the
Should have been handled in the due course, Senator, when he came in.
I would disagree with that. I've been on this committee 44 years.
I think if the senator had asked the same question again in the correct way, I think he would have gotten a yes or no answer. But the fact is, you can't argue and question at the same time. If the witness is non-responsive, you have to stop the testimony and make them answer. Now, in trial, you have the advantage of having the judge there to force the witness to answer. Here, of course, there is no neutral judge to force the witness to answer. You can't object as non-responsive and get the judge to step in and make the witness answer. And the witness here, Judge Kavanaugh, has every incentive to waste as much time as possible, knowing that the senators only have 5 minutes for each person. Despite the witness having every incentive to waste time, there are plenty of tactics that you can use to get the witness to answer yes or no. Now, first of all, you have to ask a yes or no question. This doesn't work unless you ask very pointed questions, which a lot of the senators fail to do. But if you are phrasing your questions correctly in the form of a yes or no question, and the witness is still non-responsive, here's an example of what you can do. You can say, thank you for that answer, but my question was different. My question was, and then just repeat your question. And then if the witness is still non-responsive, then you escalate it. You interrupt the witness and say, I'm sorry, the question that I asked was yes or no, blank, and then re-ask the question. Now, if you have more time, then you can try and get the witness on your side by explaining that you're trying to get an answer to your question and that the other side will have the opportunity to allow you to expound on your answer, but you're just asking for a yes or no question. So I don't want this to seem like it should just be an incredibly aggressive process. It sort of depends on the witness. But there are a ton of rhetorical devices that you can use to get yes or no responses to accurately phrased questions. And here, unfortunately, I don't think a lot of the Democratic senators had much trial experience and didn't have a lot of the rhetorical devices in their pocket that they should have. All right, so let's think like a lawyer in regards to this question. In other words, let's try to come up with the strongest arguments on both sides of this issue. I think the Democrats would argue that these answers don't comport with anyone's reasonable expectation of these particular words, and the only explanation is that Judge Kavanaugh is trying to avoid the truth in order to get through this hearing. They don't comport with common experience, and they are not accurate representations of these words. I think that the Republican response would be that the Democratic senators failed to ask good cross-examination questions. They failed to pin down the witness. They allowed the witness to evade the questions and give the answers that he wanted to give, and failed to pin down the witness to a particular answer that qualifies as the legal definition of perjury. Now, there is a separate question as to whether a nominee should evade questions and obfuscate, but that brings us to our second question. Did Judge Kavanaugh display a judge-like temperament? Now, any judge holds a special position in society. They are the arbiters of our disputes. Theoretically, they should all be impartial. They need to be able to hear both sides and make judgment calls that have a huge effect on the litigants' lives. Now, justices of the Supreme Court are appointed for life, and they hold an even higher place in our society. They literally make life or death decisions sometimes. So it's not surprising that both judges and justices are held to a very, very high standard. They are supposed to be neutral. They are not supposed to take a partisan stance. They are supposed to be able to be the neutral arbiters of our general disputes. In his opening statement, Judge Kavanaugh made some very provocative statements about the backlash being a result of revenge from the Clintons.
This whole 2-week effort has been a calculated and orchestrated political hit, fueled with apparent pent-up anger about President Trump and the 2016 election, fear that has been unfairly stoked about my judicial record, revenge on behalf of the Clintons, and millions of dollars in money from outside left-wing opposition groups. This is a circus.
Judge Kavanaugh also got into a sparring match with Senator Klobuchar when she asked about past drinking.
I think you've probably had beers, Senator, and so
you're saying there's never been a case where you drank so much that you didn't remember what happened the night before or part of what happened?
you're asking about, blackout. I don't know, have you?
Could you answer the question, Judge? That's not happened. Is that your answer?
Yeah, and I'm curious if you have.
I have no drinking problem, Judge.
Yeah, nor do I.
Okay, thank you.
And Judge Kavanaugh also got into some sparring matches with other senators about some pointed questions.
Did the word, Ralph, you used in your yearbook
I already answered the question.
alcohol?
If you're,
Did it relate to alcohol?
I like
You
beer.
haven't answered that.
I like beer. I don't know if you do.
Okay.
Do you like beer, Senator, or not? What do you like to drink?
Next one is,
Senator, what do you like to drink?
Judge, have you,
So let's think like a lawyer. I think the Democrats would probably argue that this shows a character for not being impartial, for taking partisan stances, and that his hot-headedness shows that he doesn't have the temperament to be a Supreme Court justice, who we hold to a very, very high standard. Not to say anything of the allegations of sexual assault that have given rise to this whole hearing. I think the Republicans would probably respond that he should not have been asked these questions in the first place, that they weren't proper to begin with, and that he is understandably angry for being put in this position. Now, I think we can make another parallel to some trial law. As a rule of evidence, generally, character evidence is not admissible at trial. But the main exception is where the accused has made character an issue. And they usually do that by calling a bunch of witnesses to explain how good of a person they are and how they never could have done the underlying crime. Now here, Judge Kavanaugh has done something similar. He has essentially said that he was not a heavy drinker, he has never blacked out, he has never used sexual slang in the context that he's alleged, and he has never engaged in inappropriate sexual behavior. In some ways, if we were to draw a parallel to a trial, this has opened the door to test his veracity for truthfulness and also to show whether these superlative statements that he's making are true or not. So, do you think that Judge Kavanaugh displayed a judge-like behavior? Let me know. I leave it to you. Now, that takes me to issue number 3. Would Judge Kavanaugh, if elevated to the Supreme Court, prevent an investigation into the president or the White House? Now, a lot of pundits have argued that Judge Kavanaugh in particular was nominated to the Supreme Court because he holds an idiosyncratic view that the sitting president cannot be indicted civilly or criminally. A lot of this stems from a law review article that he wrote in the Minnesota Law Review called The Separation of Powers During the 44th Presidency and Beyond. In that law review piece, Judge Kavanaugh argued that Congress should pass a law that while the president is in office, he should not be subject to civil lawsuits or to criminal investigation or prosecution. He explained that based on his firsthand experience in the White House, he came to believe that the job of the president is, quote, far more difficult than any other civil position in government, end quote. And he also says that the president must be able to focus on the tasks of being president and shouldn't be distracted by civil or criminal trials. Judge Kavanaugh recognized the irony of his position given that he started his legal career in the independent counsel's office with Kenneth Starr during the Clinton impeachment investigation, and he imposed exactly the kinds of burdens that he's saying a sitting president should not have to deal with. So, let's think like a lawyer about this position. I think the Republicans would argue that the Supreme Court is supposed to decide what is mandated by the Constitution, and they should not let their individual policy preferences guide their decision-making. A Supreme Court justice is supposed to interpret the Constitution and not make policy by fiat. And I think the Republicans would argue that this law review piece is advocating that Congress pass a law and not that there is a constitutional mandate for this particular policy position. And in fact, Judge Kavanaugh has made statements to that effect that he recognizes his policy preference is not mentioned in the Constitution and may contradict what's in the Constitution, and therefore his stance as a sitting justice on the Supreme Court is not informed by this particular law review article or the policies that he advocated. I think the Democrats would argue that while that's nice in theory, isn't it funny how often policy preferences line up with one's own personal theory of what the Constitution mandates, what it says, and what needs to be interpreted as a result of the Constitution? Upon being elevated to the Supreme Court, they suddenly find a textual reason for their particular policy preference. The bottom line is, I don't think we know for certain which way Judge Kavanaugh would rule if he was elevated to the Supreme Court. You can argue both ways based on his prior statements. So that takes us to question number 4. Would Dr. Christine Blasey Ford's allegations of sexual assault hold up in court? And otherwise, could they lead to Judge Kavanaugh being convicted of sexual assault? Now, criminal law has the highest burden under the law. The prosecution, in other words, the people making the claim, must prove their case beyond a reasonable doubt. Now, the accused technically has no burden at all. If the prosecution doesn't meet their burden, then the defendant should not have to make any showing in order to avoid conviction. So to decide if the allegations would hold up in court, we need to look at the evidence. Now, there is one statement that I see coming up in the news a lot that I think we should talk about. A lot of pundits have argued that there is no evidence of sexual assault. One of my biggest pet peeves as a lawyer is when people refer to a he said, she said scenario and refer to it as if there is no evidence. Even if there is only he said, she said with no physical evidence, there is in fact evidence in the form of testimony. Imagine if you had a police officer who testified that she saw a bank robber rob a bank. The bank robber could deny that, and technically that is a he said, she said scenario. But I bet you would probably think the first-hand testimony of the police officer was pretty strong evidence. And in fact, often you get people talking about circumstantial versus direct evidence. And this is another one of my big pet peeves. Circumstantial evidence is evidence that relies on an inference in order to connect it to a conclusion of fact. For example, DNA evidence at the scene of a crime. By contrast, direct evidence supports the truth of an assertion directly without the need for additional evidence or inference. So I don't mean to imply that circumstantial evidence is ever inherently bad or weak. Often circumstantial evidence is the strongest evidence that there is. But in this particular case, we happen to have direct evidence. We have Dr. Christine Blasey Ford's testimony. Now, you may believe her testimony or you may not believe her testimony, but if this were a court of law, that would still qualify as particular evidence. It would be direct evidence in the form of her particular first-hand testimony of what happened to her in 1983. So, as a threshold matter, there is evidence. There is evidence on the side of Dr. Christine Blasey Ford in the form of her testimony, and there is evidence on the side of Judge Kavanaugh in the form of his direct testimony. And that is separate from the question of whether Dr. Ford's testimony would meet the burden of beyond a reasonable doubt. I don't know how a jury would come out on this question, but as we discussed with perjury, I'm not sure that whether something meets the technical legal definition and the hurdle of beyond a reasonable doubt is really beside the point or not. So that brings me to question number 5. Should Judge Kavanaugh have requested an investigation? During the hearing, the Democratic senators asked a lot of questions of Judge Kavanaugh, asking if he would be in favor of a further FBI investigation into his conduct and what Dr. Ford alleges happened to her.
So I'm going to ask you one last time. Are you willing to ask the White House to authorize the FBI to investigate the claims that have been made against you?
Well, I'll do whatever the committee wants, of course.
And I've heard you say that, but
The witness
I've not heard you answer a very specific question that's been asked, which is, are you willing to ask the White House to conduct an investigation by the FBI to get to whatever you believe is the bottom of the allegations that have been levied against you?
And whether he should have requested an FBI investigation probably depends on your definition of should. As an attorney, I can't imagine a situation where I would counsel a client to ask for a further investigation of that client. Speaking as an attorney, it's usually not a good idea to encourage an investigation into your client. And just because you don't have anything to hide doesn't mean you have anything you actively want to share. But that particular legal advice would have no bearing in this particular case as to whether calling for an investigation would be a good PR move or whether it is the morally right thing to do. I'll leave that to the moral philosophers because this is not a legal question. This is a political, ethical, and moral question. And in general, you don't want to ask your lawyer for philosophical advice. So, do you agree? Leave your objections in the comments and let me know what other pressing legal issues I should cover next. And as always, I'll see you in court.